Good morning, Bill. How are you doing today?
Very good. Good morning, Ashley.
Good. We didn't have as much snow as New York City has, which is a blessing for us.
Yes, it's been a good couple of weeks with snow on the ground in the DC area. I was glad it was gone, so this won't
Yeah,
last
I
long.
know. It finally melted. So it was it still have like a little bit of a snow creek on side of the road. You and I actually live not so far from each other, which is when people say Aldi, Stone Ridge, people was like, where are you? So when you actually know where I am, I was like, wow, that's pretty cool. We have to meet up, and we did meet up.
Very cool. And a lot of technology work going on out here where we are near Dallas in Virginia. And so it's good to meet someone else in the patent world out here as well.
And not to mention, we're both Howrey alumni.
Yes, both,
Not at
both,
the
a,
same time, but I think that we do know quite a few of the same people. And I
yes.
remember, I guess when I did some research, you used to have a firm with Alan Fisch Sigler.
Yes, that's right. That was one Howrey alum that I practiced with for a very long time, over 2 decades, and it was a wonderful journey with Alan. Now we're both on doing some other things, but being a Howrey alum has been a great thing personally and for our careers over the years. I'm sure you found as well. It's a great network of people who all either started at the same place or cross paths at the same place, and have gone on to do a lot of very interesting things in the law.
We did not cross path while we were at Howrey. I started at 2000 and left in 2001. So it was maybe 11 and a half months. I did do like a telecom case. And so the people that I work with primarily, it was a Bob Ruya case. I worked with primarily like Brian Rosenthal, Lisa Sachs, Chris Olsen, Matt Moore,
Oh
all
yes.
from different walks of life now. Jay Giuliano, Pamela Kane. So a lot of really cool people there. So I think that when I talk to some of the other alumni, they say, oh yeah, I know them, but I think that I have such a short time before I decided to leave and focus on really IP because Howard, was still a GP firm. So I wanted to do a little bit more on IP work. So that's one of the reasons why I left. Can you share with us about your journey and how did you get into IP and also the time since Howard to the time that now you started your own firm, Lex Arx?
Sure. Happy to do that. So I always kind of knew I wanted to be a litigator. I was a paralegal before law school and got to do some really interesting white collar criminal cases and some civil cases. And so knew I wanted to litigate. And so after law school at UVA, I started at Howrey in 2003 and didn't really have a specialty I wanted to get into other than I wanted to litigate. And Howrey was a great place for that with a really strong general litigation practice and antitrust and some IP. And so I worked on a few different litigation matters, general litigation, antitrust stuff for my first year there and worked with some really great people like Doug Baldridge and Vince Verrocchio, who are fantastic litigators, and they've gone on to great things over at Venable, and ended up after about a year starting to work with Alan Fish on some cases, particularly one in the Eastern District of Virginia, where he needed some local counsel, and I'm a Eastern District of Virginia attorney. So I started working with Alan on some IP cases over there and really hit it off with him and some other people on his team like Kelly Clement and Coke Stewart and some other people, Kevin Jacobs, another one who I've known for over 2 decades now as well, and started working almost exclusively on patent cases with Alan, despite the fact I don't have a technical background and didn't have a particular interest in the field before getting into it. But I really enjoyed working with that team. And for me, that's really the key to having a healthy and a good career in litigation. You got to find the team that works for you. Spent about 2.5 years at Howrey, and then Alan moved our team over to K. Scholler, a big New York firm with a DC office of about 50 attorneys. And we practiced there for about 6.5 years until 2012 and had a great run there. Really enjoyed working at K. Scholler. It's a fantastic firm, great leadership, great people there. And then Alan and I decided to start our own firm. And that was in 2012. We started Fisch Sigler then and had a great 12-year run litigating at Fisch Sigler. Several big trial victories. We really focused on trying patent cases to juries and had some great results there. And like I said, it was a great 12-year run. We both kind of determined at the same time that it was a good time to wind things down with Fisch Sigler. Alan actually decided to essentially retire from practicing law, which was fantastic for him, and he was at that stage of his career. And I ended up taking a little bit of a break from litigating and helping out with a startup company for a little while and helping to wind down Fisch Sigler and all that goes with that. And that time really helped me figure out what I wanted to do and a path forward. And that led me to founding LexArx, a new firm that was set up a little differently and is going to focus on some different things than we focused on at Fisch Sigler. And we opened the firm actually last week and very excited about it.
Congratulations.
Thank you. Thank you. It's a process starting your own law firm, and I've done it twice now, and doing it a second time was smoother and a lot easier in some ways than the first time, as you can imagine. But yes, very excited about it. And here we are.
How do you, or do you even differentiate the first time when you have a partner going in and then the second time that you are starting your own? Do you have any mindset differences in setting it up? You do have the experience, but it was with another partner. So a lot of times that you could have some consultation, but now you have all the control. You shoulder all the responsibility. So does it share with us, how does that differ for you as a founder?
Sure. It's very positive in one way, and then also a little scary and negative in another way. It's
like all things in life.
sure. I mean, when you have partners, and Alan and I over the years at Fisch Sigler had additional partners as well, but when you have a leadership team like that, it is a nice resource to bounce ideas off of and, divide and conquer on some tasks and issues and that type of thing. But starting it out on your own is also fun and exciting in other ways. I mean, you can do things how you want to do them, which it's fun and exciting, but like I said, a little scary as well. But having that, singular control and singular mindset and ideas, it does help you in ways like you can just run with it. There's no one really to bounce ideas off of or to, essentially get approval on ideas. You're the idea generator and approval all in one. So it's definitely a little different, but I've enjoyed it so far. And I think it's a good place to be in my career. This is something I wouldn't have been able to effectively do 10 years ago, even. I needed that experience to essentially helping to run a firm for that many years.
That's cool. I mean, I totally understand and share the fear because I started this on my own as a paralegal. When I decided to leave and started my own company, I honestly was just really seeking for a more control over my own life and not so much just litigation hours. And I do know that if I go from one firm to another, I have worked in litigation for over, I want to say maybe about 30 years, and then started out with construction litigation. And so a lot of transferable skills, litigation, I've been litigation the entire time until probably when AIA come out, I started maybe a year after that, I started getting trained to do PTAP cases. And then my trainer eventually left. And so I was like, what do I do now? So I ended up getting promoted to be a PTAP litigation assistant coordinator to help train other people in the department to establish best practices and supporting attorneys. Eventually, when my dad died in 2017, I was working even harder because I didn't want to deal with emotion. And so classic avoidance.
Sure.
And you You get overtime, you can do all these things, and you don't have to deal with your emotions. And then finally, it hit me in 2019. And I was like, I don't think I can do this anymore. I did have offer from other people, like, do you want to come to our firms and this and that? Grass is not always greener on the other side. I've been doing this for a while. So I thought that maybe I'll do something different. And I talked to a litigation paralegal and she turned consultant. Her name is Melissa Quelan, and she started her own firm, ILS Consulting, and she does like trial practices, ITC, things that I do not do, but we became friends after a mutual acquaintance recommended I talked to her. And so networking is so important in this space, right? So I talked to her and I'm like, I don't know exactly what I'm going to do, but I think that I need to do something different. She gave me she shared like about 15 minutes of her time and we became friends after that. And she kind of gave me like the roadmap of the things that I should consider. And after that, it was like 8 months. I was like, do I do it? Not do it? Consult with my whole team, me, myself, and I. And eventually just pulled the plug and decided that I'm going to do it. And I do know a lot of people in the space. Before I even started the LLC, I already had people asking me, when do you start? And I was going to do March 2020. Which is COVID. I ended up doing it in January 2020 because I already have cases. Like people came in and
Mhm.
asked me and said, hey, so and so told me that you are starting in something. Can you cover me? We could see, but I need to start an LLC first. So since then, this is now year 6. It has been a roller coaster ride and a lot of good lessons. Now, my company is Virtual Patent Gateway. I always am very curious about how people, founders, find their name. So yours is Lex Arx. Share the origin of how you named this
I
firm.
wanted to have a name that will allow it to grow because the goal of the firm is to not just have Bill Sigler as the lone litigator. The goal is to build this up just like we did with Fisch Sigler. We started with 5 or 6 attorneys there and built it up into 15 attorneys and, several legal assistants and administrative staff. That's something I want to do here as well. So I didn't want to just use my name.
You
And
wanted to live on.
I have in my mind the ideas of we're starting off very focused on patent litigation and certain aspects of patent litigation and don't, want to cabin ourselves into that space. There's, other IP matters we like to get into and perhaps even beyond that. So that, of course, starts the search for a name that allows you to grow and that nobody else is using in the space. And there was a lot of brainstorming and bouncing ideas off of different people and finally arrived at LexArx, which Lex, of course, is law or legal, and Arx is basically means citadel. And I think as we'll talk about a little more today, our aim, at least at the outset, is to provide protection and a citadel for our clients in the legal world, and particularly in the patent litigation space that we're in today. So that's why we're called LexArx. Naming a company, as you know, is a real process.
It is a real
a
process.
lot of different things to consider. I've done it a couple times now. I feel like I've gotten better and more efficient at it, but it's always going to be a process.
It's always going to be lessons learned. You never know, especially with AI and a lot of things that is
Sure.
changing the landscape of today's legal landscape. So the next question I have is that you describe your firm as offering new and different solutions for handling patent dispute. What makes LexArx different?
A couple different things. I think the first thing, and I just alluded to this earlier, is we really want to be focused at the outset of our firm on protecting our clients against non-practicing entity actions and doing it as economically as possible. So really the services that we're focused on providing are aimed at efficiently and effectively resolving threats, non-practicing patent entities that send our clients, for example, a demand letter notifying them of their patent and suggesting or outright alleging that they need a license. Or some MPs just file a case and go from there without a letter. And the demand letters cases are really multiplying these days because of the landscape in patent law that's developed over the last year plus now. And we're very focused on providing options to address those threats and resolve cases early on and offer our clients access to various responsive or offensive actions that they can take in response to those actions, like filing a declaratory judgment action, for example, or filing a reexamination at the patent office, among other things. And I'm also very focused on providing economic flexibility for clients that will meet their particular goals for the particular litigation or demand letter that they're receiving. That's something that many small firms can provide far better than large firms typically can. And I'm very excited about some of the fee structures and flexibility in that area that we're going to be able to offer. And I'm certainly drawing from my prior 12-year experience running another small firm to develop those options.
Small but mighty.
Yes, that's the idea. Like I said, very focused on addressing these threats from NPEs early on the start of a dispute or litigation. I think that's very important in today's landscape. But I have a lot of experience taking cases to trial. I've tried many cases before juries, and then beyond that, argued many federal circuit appeals. So I feel like we can offer a good picture of what is important in a litigation from demand letter all the way through trial and appeal.
So the jurisdictions that LexArx would cover would be district courts, federal circuit. Do you do ITC work?
I don't do ITC work.
Oh,
perhaps that would be maybe
there are
down the
people
road.
that can handle that type of quality of life, and I'm not one of them.
As you well know, it's a very specialized court and proceeding, and there are very talented attorneys out there who specialize in those types of cases, and more power to them. I will readily say that I'm not an ITC attorney, but if you have an ITC matter, I certainly know attorneys who can handle it.
So do you do anything before the USPTO then? Like PTAB and then ex parte? How does that work for you? We have the federal jurisdictions, and do you do any USPTO work then?
Yes, I do intend to do PTO work and have done work there over the years, from drafting and filing reexamination requests. And same thing with IPRs. I've argued several of those at the patent office, and then beyond that at the federal circuit. So those are services we will be offering. And of course, the IPR landscape has changed drastically in the last year or so, and things are shifting a bit more to ex parte reexamination practice. Although in my practice at Fisch Sigler before this, we'd kind of seen that a bit as well. And actually, we're doing quite a few ex parte reexams in the last couple years as well, even before the shift in rules and procedures over the last year or so.
My practice definitely has shifted from heavily on IPR PGRs, and then mostly IPRs. And then for the maybe 3.5 years ago, I started finding myself having to learn how to do ex parte. Like I said earlier, I was a litigation paralegal the entire time. I'm not a patent prosecution paralegal. IPR and PGR still resembles a lot of the litigation, even though it's before the PTAB re-judges the body. But ex parte is so much more prosecution-like. And so I find myself struggling a little bit. But so, one of the things that I like to do is learn. So I go and, read new things. And I do organize a lot of webinars to get people from the industry to speak and give them visibility as well as learning. Because that's, what better way to learn than have some of the industry leaders? Yeah, so the last few years, it's been really switching to a majority of ex parte versus IPR, PGR. But I still have some other clients that wanted to do IPRs. So that's been very interesting lessons learned, because the rule, like you said, changes a lot. The discretionary denial procedure have changed a lot, and it's not necessarily great for petitioner based on the institution decisions, like how it actually changed in terms of the procedure. So that has been a lot of lessons learned for me, because it's not so straightforward anymore. It was never straightforward, but now it's just every time when you learn something, it's oh, that changed again. There's another memo, So that was really interesting. Can we talk a little bit about leadership? Modern patent litigation nowadays, compared to maybe a decade ago when you and Alan started Fisch Sigler, how do you view leadership, say, a decade ago compared to now? So, for example, at large firms, the structure is very top down. At least traditionally, that's what I have actually experienced. When you run a smaller firm, you have a lot of autonomy. What lessons, for example, do you have from your previous litigating experience that you want to apply now because you have that autonomy? One of the leadership lessons that Simon Sinek always talk about, one of the edX author, TEDx speaker, is like start with why. And the thing that he talks about is usually when you're in a room, be the last to speak. I wonder, how do you feel about that as a managing member of LexArx?
And I didn't invent this. I'm a big proponent of, and we were at my prior firm as well, of best idea regardless of source. So anyone on the team, from the partners leading the charge to the legal assistants, we wanted their input. If they had an idea about a particular strategy or a particular witness, anything like that, or a process we were using, we wanted to hear it. Doesn't mean that, I always want to hear that. Doesn't mean that it's necessarily the best answer for the problem we're trying to solve, but you need to allow your team members to provide input for a couple of reasons. One is you get really good ideas that way. I mean, I don't have all the answers for sure. I don't even want to say secondarily because I think it's important, but you want people to know that their contribution is valued on the team. I think that's absolutely critical to achieving success. And that's certainly the way I'm going to operate going forward. And I think it's a little different than the way things worked, at least at the large law firms where I worked. And I think that's probably still the case. It was a very hierarchical model, and certain people, their word was law, and that's the way you were going to do it. And I don't operate that way. And I don't think a successful litigation team really can operate that way.
Next question. I love this. David versus Goliath question. You've defended Fortune 5 companies and small retailers alike against patent trolls. How do you now tailor your patent strategy depending on who's sitting across your the negotiating table or the counsel table?
This is somewhere that I feel like I have a lot of good experience and perspective to offer. And it's one reason why I actually wanted to start the firm and kind of focus on what we're trying to focus on. I've represented big technology companies, like you said, Fortune 5 companies that are battling dozens of patent cases at a time. But I've also represented plenty of retailers and others who may not be what we would think of as small companies, but they're not as likely participants, or they don't participate as often in patent litigation. They may be facing one patent litigation issue a year or every couple of years or something like that. You obviously need to treat those clients differently and understand what their goals are for the particular case you're working on and what their goals may be for the greater set of litigation or legal issues that they're dealing with. So you really have to know your client and their goals, and then also the party on the other side and their counsel and what court you're in. Some non-practicing entities out there may have a really strong desire to only pursue cases in one particular jurisdiction, while others they're fine litigating in any jurisdiction. So you have to know how the party on the other side may react to an early motion to transfer the case or an early motion to dismiss the case. How are they going to react to that variable? What impact will that have on how quickly and efficiently you can resolve the case on behalf of your client? So we really try to focus on those variables, like I said, on what our clients want to achieve in the particular litigation.
With that, small or large, trust is so important with clients. How do you build trust with your clients?
I like to make sure that the lines of communication are always open and constant updates are flowing to the client about what's going on in the dispute or litigation. I think that's absolutely critical. That's certainly one area for building up trust, but also being very honest with the client about particular results or things that happen in the case and how that may impact our case going forward. I've always prided myself on not sugarcoating or hiding bad bad things that happen in litigation. Because, I mean, as you know, having been in litigation for so many years, you're not going to win every motion and you're not going to have every witness perform outstanding at a deposition. So clients need to know that. They need honesty about how a particular ruling or fact may impact the litigation and where we go from here. So I think that's very important in building up trust.
Yes, totally. I think being honest, it's so important. It's the hardest to be honest. It's like, oh, it's obviously when they hire you, they hope to have you win everything, but sometimes it's not practical and realistic. So being honest, I think that sets the pattern that they know that they can trust you to be candid with them so they can actually plan their case strategy forward. For company facing patent disputes these days, what should they prioritize beyond winning the case?
Sure, that's a great question, particularly given the current landscape of what's going on, where given the kind of change in the law and procedures with regard to the patent office and some other things, this is really a time of what we're seeing is an uptick in patent litigation from non-practicing entities. So clients really need to focus on what their risk profile is in the patent space and how that might change going forward. With a lot of funding flowing to non-practicing entities and people wanting to back patent litigation campaigns, a client who perhaps has only seen one or two patent litigations going on at a particular time, may see that increase as 2026 goes on and beyond. So I think clients need to be aware of the trends in the patent litigation space and how their risk profile may increase. And so part of that is up to each particular client as to what message they want to send to the non-practicing entity and plaintiff world. Are they apt to resolve cases early on for a settlement amount, or are they apt to take actions to aggressively resist in each litigation? Or is it something in between, or is it a particular strategy to match a particular set of plaintiffs or issues? All that is very important to think about. What message do you want to send to repeat players out there in the non-practicing entity space and their counsel?
I like that answer a lot. Very strategic. Kind of not only look at it in one instance, but what do you want to represent to the players outside? Now, final question. Looking ahead, what excites you most about where patent law and technology AI are headed, especially now that you started LexArx?
Yeah, that's a great question because it's such a dynamic world right now, both in terms of patent litigation and, of course, just more broadly with AI and technology constantly developing. I think one of the things that has made me most excited, particularly over the last couple of years, is just some of the efficiencies gained from AI and other technology that can take in appropriate circumstances
Yes.
some of the
Still
busy
have to
work.
review.
Yeah, absolutely. But some of the busy work out of litigating, that's helpful. I mean, in terms of, setting up a pleading for you or setting up a motion for you or various organizational pieces that need to be done. And it's nice to have that efficiency there where appropriate. And that allows you to, as a litigator, to focus more on where you want to focus and your client wants you to focus on strategy. How do we want to address this new complaint that's been filed? What are the options? So it allows you to focus more on strategy and winning for sure. And there's, of course, just a bevy of new products out there. Every one of them talks about AI and, has different things to offer in the litigation space, not all of which may be good, but I love efficiency in life and litigating and everything else. And I think there's great opportunities for that. I mean, I remember as a legal assistant and even, my first couple years at Howrey, I mean, we were reviewing hard copy documents by hand and separating them into different piles or the hot docs box or what have you. I mean, I remember going around where we subpoenaed a bunch of third parties and going into conference rooms and looking at the hard copy documents and all that good stuff. And of course, shifted fairly quickly after that, to more electronic discovery process. But, seeing that continue to evolve is pretty fascinating and provides you a lot of opportunities, like I said, to be more efficient and focus on strategy and winning, or even focus on, and, it's more easy to find particular facts that will help you win in litigation, whether it be at the motion stage or at trial or somewhere else. So I think all that's great.
You want to hear a funny story about like my early days in litigation and how like old days base numbering, like printing those labels and putting like really old school. I mean,
I remember.
I'm not even doing like the base stamp, right? Doing the
Right.
label and everything. So one of the firm that I worked at before, and I was new. That was my very first case. And I usually do indexing. So we have like 30 boxes. I'm like having my tabs and I was like, hey, we need an index so that we can find the hot dog, right? And then as I was looking at this, like box one to whatever it is, there's 100,000 pages of gap in base number. And each box is probably about 2,800 to 3,000. It depends on how you pack them. Now I'm really going old school now.
Right.
Right. So like, wait a minute, where is this? And it's like stored in like a workroom. And so I went and asked like the previous, like some of the associates, like something doesn't add up. There's over like 100,000 pages, not quite here. And I'm not sure. Do you think that they, is it maybe they made a mistake in the base numbering? I'm like, I don't know. Maybe they haven't sent everything and they just didn't bother to like strategize. And so it's like a gap in between. And I said, do you think that I have the permission to call the opposing counsel paralegal and try to figure out exactly what's going on? I mean, if it's that, we serve or intentionally left blank, fine. I will just note it in the index. And then I call the paralegal on the other side and she goes, oh, no, we still have some boxes that we haven't sent to you guys. We haven't got to it yet.
Wow.
I was like, so of course I went to the managing partner. I was like, oh, I think we're expecting another 15 to 20 boxes here based on whatever it is. And then they were like, how did you find out? I said, there's a huge gap in the base number. And so they were like, the partner sent an email to the team was like, actually just find out that there's some more boxes that are coming for document review. So those are like really important things that I feel that AI is great in terms of like you don't have to have like a team of tabs to do like 30 boxes of indexing and now also electronic discovery. But those are very important. Like I thought that was like a win by being detail oriented because like they had no
Sure.
idea it's coming. But the other thing that I think that was so important with, like you said, in the old days, you have like people in the conference room and then sometimes it's a lot of fun to be with a lot of people to just, it builds the team camaraderie and it builds like the team chemistry. And I feel like that nowadays people are just at their individual computers and wherever they are. So sometimes I feel like that the team chemistry can be lacking if the leadership does not intentionally build it because everybody can just work wherever they are with their laptop. And then it's just like deadline after deadline and not necessarily having that socialization part of it. And I felt that that was a little bit of a change in the industry that was not necessarily great.
I agree. I mean, that is a challenge, especially post COVID, where everyone is very suited to working remotely. And it obviously has many efficiencies. And I think COVID resulted in some good things for litigators too.
Yeah.
Like it's been great having just kind of your routine scheduling hearings and things like that in certain courts just on Zoom rather than, having to fly across the country for a 10-minute hearing about a schedule. I think that's been great for judges and chambers and litigators and everyone. But I agree. It's definitely a little bit challenging to build up team chemistry and make sure that people are comfortable with offering their ideas in the virtual space. It can be a real challenge.
Speaking of virtual space, 2026, typically I would have gone to like the podcast studio to just basically do my podcast. Today, I was like, let's do a virtual one. I'm like, oh, do I want to have the raccoons in the back? No. I look at outside the eyes and everything. I'm like, I'd rather to be in Iceland. So I just pull up a picture of a waterfall in Iceland, matches with my sweater. It's just really amazing in the sense that I can can actually connect with another Howrey alumni, someone that I'm very
For
excited for
sure.
your adventure coming ahead.
Yeah, I'm very excited too. Gotten a lot of great reaction from the legal world, from a lot of Howrey alums, actually.
Well,
So,
they are everywhere.
I mean, they are everywhere. It's almost like having an alumni network from a college or law school since everyone kind of dispersed 15, 16 years ago. And so that's been great. Really enjoyed that as well. There's always a connection somewhere, for sure.
Yes. If you will it, they will come, or if you build it, they will come. Field of dreams.
Right, right, right.
Well, thank you so much, Bill. I hope that this has been an enjoyable experience for you. It has certainly been great to reconnect, even though we didn't know each other first round, but just the fact that we are alumni. So I'm really, really grateful for this time to be chatting with you. I'm excited to hear about what's come next. Can't wait to hear all the success stories you share for LexArx.
Thank you very much, Ashley. It's been great. I've enjoyed the conversation. Really appreciate the invite to talk with you.